Court is concerned, it does not require the 34 judges which it's having now. Once it is relieved of all these burden of rent control, matrimonial, and so on, the result of it is that 15 judges sitting in 3 constitutional benches of 5 each would be sufficient to dispose of cases of a constitutional nature, something where death sentence is involved, or the constitutional requirement of references and so on. Now, if they are therefore able to do this, the judges will have a long leisure. They'll be able to sit back. They'll be able to hear patiently. They'll be able to write excellent judgments. They are writing very good judgments now, but they could improve on that. They would be able to read the textbooks on law which are written in various other countries, including India, and find that they introduce these into their judgments so that the thoughts and ideas. Now, today we have 34 judges, but there was a very, very prescient article written by Justice K.K. Matthew, one of our eminent judges of the Supreme Court, in an article published in 1982, 3 Supreme Court cases. He had said that with visionary foresight that he could envisage in due course a Supreme Court consisting of as many as 100 judges. If this is to be true, then I would say that so far as we are concerned, we are admitting to a failure to regulate and structure our court system in a manner where it will be able to bring justice swiftly and reset reasonable prices to the litigants of this country. It should be remembered that so far as the right to access to justice is concerned, it is a fundamental right. And being a fundamental right, it means that they should have access to justice at reasonable cost and within a reasonable period of time. 30 years is not a reasonable period of time. And therefore, I believe that the time has come when there has to be a rethinking about the entire structure of the Supreme Court as it exists today. Because there is no use brushing the whole thing under a carpet. Are we aware of the fact as to what is the suffering that a litigant undergoes when at the trial court he has to go on from day to day and wait, and each time the case is adjourned by 6 months, and he doesn't know as to when the case will be taken up and finished. Therefore, whatever reforms are going to be done should not be restricted to the Supreme Court alone. It should think of the high courts, and it should think of the trial courts. Today, we have inherited a system which is extremely cumbersome, where the procedure in the Civil Procedure Code, which is a fat book, would result necessarily in delaying the disposal of cases. The criminal cases, of course, have to have a procedure which gives a full right of defense to the accused. But I think that the cumbersome procedures which exist should be done away with. We have the writ petitions, which can be filed, disposed of within a week or 10 days. It can never be done if you follow the procedure in a Civil Procedure Code. Therefore, so far as I am concerned, I think the time has come when I think both the government as well as the judiciary should put their heads together, because one cannot allow today's situation to continue, because we are not really doing justice. We are ignoring a fundamental right, perhaps violating the fundamental right by allowing this structure of courts to remain. Thank you.
Thank you, sir. May I now request the Honourable Minister of Law and Justice, Shri Kiran Rijiju, to share his thoughts.
Honorable Prime Minister of India, Shri Narendra Modi ji, Honorable Shri Justice NV Ramana, Chief Justice of India, Honorable Justice U. Lalit, Judge Supreme Court, Honorable Sri Justice D.Y. Chandrachud, Judge Supreme Court of India, Sri K. Venugopal, Honorable Attorney General of India, Honorable Judges of the Supreme Court, Honorable Chief Justices and the Judges of the High Courts, Sri Vikas Singh, President Supreme Court Bar Association, senior officers of the Government of India, learned law officers, friends from media, ladies and gentlemen. I am deeply honored to be part of the celebration of the Constitution Day today to commemorate the adoption of the Constitution of India by the Constituent Assembly in 1949. The observation of the Constitution Day started in 2015 based on the vision of the Honorable Prime Minister Sri Narendra Modi ji to give due recognition to the significance of this historic day. As we all know, the Constitution of India is a living document and has stood the test of time. This sacred and sacrosanct document, delivered under the able guidance of Dr. B.R. Ambedkar, and often described as the world's finest constitution, reflects the dreams and aspirations and values of the people of India and testifies the fact that the people are the ultimate source of all the authority. That is, the sovereignty lies with the people of India. The most important feature of the Indian Constitution is that it harmonizes interests of various sections of the society and exhorts every individual to attain excellence in chosen walk of life and collectively make India a great nation. The democratic process has ensured that our masses have a sense of participation in our development. By giving them a stake, we encourage each one to make a contribution to nation building. I take this opportunity to express my gratitude to the Constituent Assembly and the founding fathers who gave us the Constitution of India. I take this opportunity to inform this august House that to commemorate the Constitution Day, Ministry of Law and Justice has launched yesterday online course on the Indian Constitution. I firmly believe that we must facilitate and ensure that every Indian is access to the provisions of the Constitution of India. The aim of taking our Constitution to every citizen of India has to be made a reality, providing an opportunity to inculcate a deeper understanding of this history, knowledge, and the perspective of our Constitution. Although the Constitution is built on the principle of separation of power, it also warrants a harmonious relationship in the functioning of the three state organs. It is imperative that all the three organs of the state must work together to ensure social, economic, and political justice for the citizens of our country. The Constitution, among many other things, also highlights several important duties of each citizen. Ladies and gentlemen, I'm very proud that today, while addressing the members of Parliament in the Central Hall of the Parliament, Honorable Prime Minister has emphasized about giving primacy to fundamental duties. We all know fundamental rights are universal. It cannot be compromised with. But it is time we give due importance to fundamental duties. The outbreak of COVID-19 has hit very hard to our justice delivery mechanism. On this very auspicious occasion, let me make on record that we deeply appreciate the contributions made by all the honorable judges of our country. Our courts have risen to the occasion and made use of innovative information communication technology means to keep the doors of justice open to all. The Supreme Court has emerged as a global leader with more than 1.5 lakh virtual hearings. The High Courts and the District Courts together have conducted nearly 1.5 crore virtual hearings since the COVID period. This is something we feel proud of as an Indian. As part of the Digital India vision, TeleLaw has emerged as an effective tool in creating an inclusive society as envisioned by our visionary Honorable Prime Minister Shri Narendra Modi ji and his precepts of Sabka Saath, Sabka Vikas, Sabka Nyay. Integrating smart technology through tele and video conferencing, TeleLaw has mainstreamed legal aid to the marginalized by connecting them with a dedicated pool of panel lawyers, either free of cost or at a nominal fees. A vast cadre of frontline paralegal volunteers and village-level entrepreneurs belonging to the local CSC neighborhood assist in awareness generation and online registration of beneficiaries needing the advice. I would like to applaud the efforts of NALSA for their special pan-India drive on citizen-centric programs to promote access to affordable justice for all, organized during the celebration of Azadi Ka Amrit Mahotsav. In the end, I am reminded of the famous quote from Dr. B.R. Ambedkar, that the Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of age. Thank you very much. Jai Hind.
Thank you, sir. May I now request the Honorable Chief Justice of India, Shri Justice NV Ramana, to address the audience.
Honorable Prime Minister of India, Sri Narendra Modi ji, Honorable Union Minister for Law and Justice, Sri Kiran Rijiju ji, my dear brothers, Justice U. Lalit and Justice D.Y. Chandrachud, brother and sister judges of the Supreme Court, Sri K.K. Venugopal, Attorney General of India, Chief Justice and judges of different high courts, Sri S.P. Singh Baghela, Minister for State of Law and Justice, Mr. Vikas Singh, President of the Supreme Court Bar Association, Sri Manan Kumar Mishra, Chairman Bar Council of India, Sri Tushar Mehta, Solicitor General of India, law officers, senior advocates, office bearers and members of the Bar Council of India, Supreme Court Bar Association, Supreme Court Advocates on the Cards Association, media friends, other distinguished guests, ladies and gentlemen, Namaskar. We the people of India gifted ourselves the Constitution 72 years ago to run our republic and as a liberal constitutional democracy. After intense and illuminating debates spread over nearly 3 years, the Constituent Assembly adopted the Constitution on this day in the year 1949. This is an occasion to recall the sacrifices made by countless patriots in the Indian freedom struggle. I feel privileged and honored to stand here and pay tribute to the freedom fighters who liberated us from colonial bondage. The struggle for freedom was aimed at emancipation, not merely political, but social and economic as well. I bow to the memory of the members of the Constituent Assembly who selflessly work day and night to present to the world one of the most modern, progressive and scientific document of the 20th century. I am proud that most of those who contributed to the framing of our Constitution belong to the legal fraternity. They were also in the forefront of the freedom struggle. Today, I am reminded the words spoken by Baba Saheb Dr. B.R. Ambedkar on the 25th November 1949 in the Constituent Assembly while moving the motion for adoption of the draft Constitution. I quote, "However good a Constitution may be, it is sure to turn out bad because those who are called to work it happens to be a bad lot. However bad a Constitution may be, it may turn out to be good if those who are called to work it happen to be a good lot." Unquote. At a macro level, our experience so far assures us that the Constitution and the institutions have been in the safe hands. It is one of the strengths of the Constitution alone that we have reached great heights in various fields. That we have reached, the nation has made great strides in diverse fields such as space technology, information technology, pharma and energy. We are self-sufficient in food grain production, infant mortality rate, life expectancy and other indicators suggest that our enhanced standing globally. Today, India is among the major vaccine producers that support immunization program world over. We are among the leading exporters of vaccines, medicines, software and many other products. It is a matter of pride that persons with roots in India are leading various international institutions of repute. I salute each one of those who made this nation progress. I would like to take this opportunity to share few of my thoughts with me. The framers of the Constitution made accountability as an integral element with respect to the legislature and the executive. However, they consciously decided to keep the judiciary on a different pedestal. They trusted the competence of the men and women who would adorn the bench in upholding the Constitution. Looking back, I can proudly claim that as an institution, the judiciary has lived up to the faith reposed in it by the Constituent Assembly. The fact that the Indian judiciary continues to be last hope for those in distress suggests that it is on the right track. For this, I give full credit to my colleagues on the bench, present and past, and the members of the bar and the registry. The commitment made in the preamble of the Constitution to secure social, economic and political justice to all the citizens impose a sacred duty upon the state as a whole. The general perception is that securing justice is the responsibility of the judiciary alone. This is not correct. To the contrary, it is all the three organs of the state which are responsible for upholding this commitment to secure justice. All the three organs are repositories of the constitutional trust, while the judiciary is the guardian of the Constitution. Its role and scope of action is ultimately limited by the very narrow of the judicial process. The executive and the legislature must work in conjunction with the judiciary to ensure complete justice as envisaged under the Constitution. Any deviation by the legislature or the executive from the path described by the Constitution will only lead to additional burden to the judiciary. The Lakshman Rekha drawn by the Constitution is a sacrosanct, but there are times when courts are compelled to pay attention to unresolved grievances in the interest of justice. The intention behind such limited judicial intervention is to nudge the executive and not usurp its role. The constitutional obligation and duty of the judiciary's intervene needs to be appreciated in this context. Attempts to project such interventions and constructive observations as the targeting of one institution by another are totally misplaced. If encouraged, such attempts will prove to be detrimental to the health of democracy. Misgivings about the constitutional scheme are mainly due to lack of constitutional literacy among even the well-informed sections of the society. Despite it being the document that decides their destiny, the vast majority of our population is oblivious of its relevance and importance. There is an urgent need to launch a massive drive to raise awareness about the constitutional rights and the duties of the citizens, as well as the roles of the other coordinate branches of the state. I am glad to learn that the Government of India launched a video series yesterday aimed at educating children about the Constitution. To take it to the larger population, more such material need to be made available to the Indian languages. A healthy democracy is known by its dynamic institutions. Every dynamic public institution needs to constantly evolve and innovate in order to keep pace with the changing times. The Indian judiciary is no exception to this. The Supreme Court of India must be on its toes and its innovative best to meet the challenges. A comparison is often sought to be drawn between the judiciary of 1950s and the present-day judiciary. It is unfair to do so. Since the Constitution came into effect, it has undergone changes 105 times through amendments. This dynamic document can evolve in tune with the times. It is only logical that the judiciary moved beyond the restrictive constitutional philosophy of its formative days. What we are witnessing now is a totally transformed judiciary. This enrichment brought about during the last 7 decades is due to more informed citizenry and rise in expectations of the people and increasing challenges of diverse nature faced by the society. One notable outcome of this enrichment is the idea of public interest litigation. I am not sure if anywhere else in the world a simple letter written by a common man receives judicial attention of the highest order. Yes, it is sometimes ridiculed as publicity interest litigation due to occasional misuse. We must be very ever vigilant to discourage motivated PILs. At the same time, we must also acknowledge the enormous public good achieved through such progressive expansion of constitutional jurisprudence. But the same judiciary, which offers solutions based on mere postcard, paradoxically, struggles for years to take regular litigations to the logical conclusion due to various complex reasons. The question is how to address the issue of protracted litigations and pendency, which is agitating the minds of the citizenry. In this context, I welcome the suggestions made by the learned Attorney General. As far as the pendency of the Supreme Court is concerned, we have initiated steps to reduce it by harnessing technology. Pendency in lower judiciary is particularly alarming. It calls for multi-pronged approach involving all the stakeholders. The solutions that we could think are structural change in the hierarchy of the courts, filling up of the existing vacancies of judicial officers, creation of more and more posts, filling up vacancies of public prosecutor, government pleaders and standing counsels, creation of necessary infrastructure, sensitizing the police and the executive about the need to cooperate in court proceedings, deployment of modern technology tools. Infrastructure development is proving to be a difficult task. I must acknowledge that the Union government has been making reasonable budgetary allocation through its centrally sponsored schemes for this purpose. But due to non-availability of matching grants by some states, the budget allocated remains underutilized. I feel the situation call for the creation of special purpose vehicles, namely national and state judicial infrastructure